All right, guys, this is Professor Harsh Kachalia, and today we are going to discuss the MCQs. The MCQs for your CA final law paper. Well, lots of MCQs are there, and of course, it's not possible to take all these 100 or more MCQs in a single video. So we will be breaking it into different parts. All that you need to do before you start watching this video is have your concepts very, very clear. For instance, the first few MCQs, I am going to start from the first chapter of our syllabus, and that is the director's chapter. If at all you want to enjoy the MCQs also, and you want to understand the concepts also, make sure your director's concept is very, very, very clear. All right. Now that we are supposed to start with the MCQs, let me ask you a question. Do you want to be a logician? A logician, that is a person with an expert in law and understands law with logic, right? So law and logic together always will make you a logician. Are you willing to be a logician? Yes. If you are, then let's get on with the competition, which begins right here. You want to be a logician? Well, answer my question number 1, which is on your screen. I will read out the question to you. In compliance with the provisions of the Companies Act 2013, at least one woman director shall be appointed. At least one woman director shall be appointed in the board of such company or such class or classes of companies who satisfies the given conditions. All right. Here the question is, at least one woman director is required on such particular companies who satisfy certain given conditions. Do you know the conditions for woman director? Attempt this question only if you are aware of the conditions, well aware of the conditions. Of course, the conditions are given in section 149. If you are a listed company, why should I discuss it with you? Yes, you try it out on your own. There is this lady, Miss Ria. She's keen to hold office of a woman director in a particular company. She's got 3 options. That is PQR Limited, ABC Limited, and XYZ Limited in option. Right? What you have to answer is, she has selected some companies, that is the 3 of this, to fill the vacancy of woman director. You have to advise her and select the companies as to which of these 3 companies compulsorily require woman director. All right. Your time starts now. All right, guys. So I assume you have got your answer. I assume you have got your answer, and the answer is, sir, 149. The conditions required are required in A also, in B also, and in C also. So, sir, our answer will be all of the above. That is the answer number D. All right. So if you have got this one correct, well, you are eligible to go on to the next one. And if you got this one wrong, then you better not go to the next one and revise your concepts all over again and come back away. Let's go on to the next question on the screen right now. ADS Agro Private Limited, a newly incorporated company. Guys, point to be noted, newly incorporated company has not mentioned the names of the first directors. Okay. The articles of association have been prepared. In the articles of association, they have not specified that who will become the first director of the company. They have not specified the name of the director. They have not specified the manner for appointment of the first director. Are you able to connect to which section this particular concept is coming from? If you are my student and still you are not able to remember which concept or which section is relevant over here, then well, I have my doubts. Are you really my student? Have you done your revision clearly, perfectly? Open the summary notes, go to section 152, read the concept, the first point itself, guys. Yes? referring to the provisions of Companies Act 2013, who shall be deemed to be appointed as the first director of the company. Your options are on the screen. A, the members of the company shall be deemed, all the shareholders, all the members of the company, they will be deemed to be the first directors. Option number B, the subscribers to the memorandum of the company shall be deemed to be the first directors. Well, if no name is given, no manner is given, shall all the subscribers of the company be appointed as the first director? Yes, until the AGM comes in. Is that the provision? C, shareholders shall appoint the first directors in the general meeting. Well, shareholders shall appoint the first directors in the general meeting. This looks logical to me, right? But then who will call for the general meeting? Sir, board of directors will call. Well, they are not yet appointed. Right? Sir, then CS will call. Board of directors will appoint the CS, but board of directors are not yet appointed. I get my doubts here. None shall be deemed to be the first directors of the company. So D says A, B, and C, all the four are wrong. You select the right answer, your time starts now. You've got 30 seconds to think. 30 seconds. Tick tock, tick tock, tick tock. Time up, everyone. And the right answer is subscribers to the memorandum will be appointed. If you know our notes, the summary notes, if you have those summary notes, well, the section 152, the first point itself, we have shown it in a diagrammatical format. Yes. First, articles of association we have written divided in two parts. Name is specified, name is not specified. Name is specified, appoint such person. No name is specified. Well, no problem. Divided in two parts again. Is the manner specified? The manner for appointment of first director, is that specified? If yes, appoint in the manner specified. But no, sir, manner is also not specified. So here we said name is not specified. Here you are saying manner is also not specified. Then all the subscribers to the memorandum shall be appointed as the first directors of the company. That's what we have discussed. All right, let's go on to the next question quickly. On your screen, turnover they have given of XYZ Limited as on the date of the latest audited financial statement. The turnover is 400 crores. An intermittent vacancy has been created in the office of woman director. Intermittent vacancy means casual vacancy. There is a vacancy in the office of the woman director on 15th of June 2018. Date to be noted, everyone, 15th of June 2018. The immediate board meeting of the company was held on 14th October 2018. That is, the next board meeting was held on 14th October 2018. By what time you should fill the office of the woman director, the casual vacancy of woman director? Think. Again, going back to section 149, the basics. Yes. Go to the provision of woman director that we have understood. In case of a casual vacancy in the office of woman director, how do we fill the casual vacancy? Normally, the provision that we have learned is within 3 months or before the next board meeting, whichever is later. Whichever is later is the provision that we have learned. Well, I've given you a hint. The answers are in front of you. Go for it. Your time starts now. The answer is, of course, sir, you said 3 months or the next board meeting, whichever is later. So what is later? Your next board meeting is the later part. 14th October 2018 is your date for appointment of woman director to fill up the casual vacancy. All right, 3 questions down. Let's go on to the next one quickly. How Textiles Limited is a listed company. It is engaged in the production of furniture and fittings in Pune. The company is having 50,000 small shareholders. The moment you read the word small shareholders, it should ring a bell. Section 151 is what we are talking about. The small shareholders want to elect a small shareholders director. They want to appoint a small shareholders director because they want to protect their interest in the company. Yes. So their issues can be resolved on priority. Their issues can be taken up to the board of directors in the board meetings. Yes. 500 small shareholders served a notice for appointment of a small shareholders. What you have to say? Decide the validity of the notice. So how many people are required to file a notice or file an application for appointment of a small shareholders director? Tell me, how many people? Section 151 has clearly stated, should I give you the hint? Yes, 1/10 or 1,000 of the total small shareholders, whichever is less. That is the hint. Options are right in front of you, and your time starts now. Time's up. And your answer is got to be 1/10 or 1,000, whichever is less. Here, notice that 500 shareholders, they say it's not valid and the company may appoint small shareholders on requisition of 1,000 small shareholders. So 1/10 or 1,000, whichever is less was the requirement. Here they say they have 50,000 small shareholders, so 1/10 comes to 5,000. So 1/10 or 1,000, whichever is less. So 5,000 or 1,000, whichever is less. So minimum 1,000 is required. And so application by 500 is totally not valid. That clear, everyone? All right. Let's go on to the next one. On the screen right now, Mr. Q. He's a director of PQR Limited. Mr. Q is a director of PQR Limited, proceeding on a foreign tour for 6 months. All right. So can you recollect the concept? Yes. A director of the company going outside India for a period of at least 3 months. Something related to alternate director might come up. I do not know, but it might just come up. Let's see. So he's a director of PQR Limited, proceeding on a foreign tour for 6 months. He appointed Mr. Y as the Mr. Q appointed Mr. Y as his alternate director to act for him during his absence. They say the articles of association provide for the appointment of the alternate directors. Mr. Q claims that he has the right because I am the director. I am going outside India, so I have the right to appoint an alternate director. Tell me, does Mr. Q have the right or no? Should I give you a hint again? Well, if you are my student, we have done this in the section 161, where specifically while talking about section 161, subsection 2, appointment of alternate directors, who can appoint an alternate director? There is a small English word, a small basic English word, which I have yelled in the class and asked you to highlight it because it's a basic English word that normally students tend to ignore. But here you see a question has come just on the basis of that basic English word in front of you. Well, that's the hint. I'll discuss the answer, but after 30 seconds. Time starts now. Time's up, time's up, time's up, time's up. And your answer is, sir, is it valid or no? Of course, the answer is not valid. Why is the answer not valid? If you read section 161, subsection 2, it is clearly written over there when a director, original director of the company, goes outside India for a period of at least 3 months, then other board of directors will appoint an alternate. Other board of director. What does it mean? It means if you are going outside India, well, I wish you a very, very happy journey. Please go. You do not appoint your alternate, and you do not teach us whom should we appoint as your alternate. Other board of directors are there in the company, and they will take good care of the company in your absence. Other was the word, a basic English word that we have highlighted in our notes. Other board of directors will appoint, and of course, not to forget, articles of association should permit such kind of an appointment. Only then you can appoint. All right. So that is your answer to the question number 5 of your MCQ. Let's go to the next one. Mr. Nagarjuna decided to resign from MGT Private Limited due to preoccupation. Okay. He's preoccupied somewhere else, and so he wants to resign from MGT Private Limited. He sent his resignation letter on 12th of June 2017 to the company, all right, stating that he will resign with effect from 15th of June 2017. 3 days notice he has given. Due to the non-receipt of the communication from the company, he dropped an email on the 17th of June, 17th of June to confirm whether the company has received the letter. Finally, the company received the letter later on 25th of June. In this case, what we have to understand is from which date will the resignation be effective. You've got so many dates over here. From the 15th of June or 12th of June or 17th of June or 25th of June or any other idea that comes to your mind. Well, I'll give you a hint to understand the concept. Yes, this is a very, very simple question asked you from section 168 about the resignation of the directors. Read 168. Yes, your answer is right there. I will discuss it after 30 seconds. Your time starts now. Time's up, time's up, time's up. And the answer will be, sir, it has to be effective from 25th June only, because as it is given in section 168, resignation shall be effective from the date on which the notice is received by the company or the date mentioned in the notice, whichever is later. Yes. So whichever is later comes to 25th of June, and that's going to be your answer. Let's go on to the next MCQ. Question is on your screen. Well, I had to keep small font because the question is quite big. HCQ Pharma. HCQ Pharma Limited Company, which is listed on the Bombay Stock Exchange, incorporated on January 20, 2002. Okay. The directors of this company wants to appoint Mr. Sanjay. Who is Mr. Sanjay? He is the managing director of Sanjay and Associates LLP, which is a firm of lawyers, as an independent director of the company. All right. So they want to appoint Mr. Sanjay as an independent director of the company. Okay. At the AGM. All right. Mr. Sanjay is acting as a legal advisor to Genesis Laboratory Limited, which is an associate company of HCQ Pharmaceuticals Limited. Mr. Sanjay has been receiving fees, consultation fees, as given below. For the year 17, 18, 18, 19, and 19, 20, he's received a big amount. I see. 2 crores, 10 crores, 45 crores. Well, The gross turnover is given as 40 crores and 50 crores. Well, the third year, I guess there is a printing mistake. In the third year, that is 1920, the fees received is zero. The fees received is zero and the gross turnover is 45 crores. Okay, we just need to split it out. All right, that is done. Next one. Next, they are saying HCQ Pharma. HCQ Pharma can appoint Mr. Sanjay as an independent director. That is option A. Second one, they cannot appoint. Third one, they cannot appoint for the given reason. And fourth one, they may appoint or they can appoint for the given reason. I am not discussing the reasons right now. Go to, should I give you the hint? Section 149, subsection 6. Who can become an independent director? If you have my notes, we have given a keyword as I am rough when. I am rough when. In that, I am rough when. ROF. Go to the F. Go to the F. We have divided it in two parts. Yes? We have divided in two parts. Check the right hand side. That is your answer. So until now, if you see all these questions that I am discussing over here, guys, these are all questions given by ICAI. Okay. None of these questions are mine. I am just discussing them with you. Right. So all these questions are given by ICAI. And up till now, whatever questions we have discussed, what we have seen is every question, the answer to every question is directly given in our notes, in our class notes. Directly, the question has been answered in our class notes. All right. Well, your time starts now. Check it out and let me know. 30 seconds. Begin. And your time is up and change of look. Well, I think this looks more better, more professional. Anyways, don't focus on the look, focus on the answer. The answer is C. HCQ Pharma cannot appoint Mr. Sanjay as an independent director. Forget the answer. Think about the logic first. Why HCQ Pharma cannot appoint Mr. Sanjay? Why? Why is this provision like this? If you have read the provision over there, what does the provision say? 149.6. It says, first of all, if you are a legal consultant, a legal advisor to the company, and you should not have provided any services to the company, holding or subsidiary or associate in the preceding 2 years, including the current financial year. Plus, whatever services that you have provided, all right, have provided the services compared to your turnover, yes, the amount received from that company should not exceed 10% of your total turnover. That is the condition that we have discussed in 149.6. Check the answer. They say, Mr. Sanjay as an independent director cannot be appointed as he is a managing partner of a particular firm, who is a legal advisor to their associate company. So if you have any connection with the holding or subsidiary or associate company, you are automatically disqualified, right? Plus, the fees that are charged, exceeds the percentage specified. What is the percentage specified? 10%, right? So the fees that are charged exceed the percentage specified. That is why we would say that Mr. Sanjay, I'm sorry. Go on to the next one. Next question coming up on your screen right now. The board of directors of MCQ Limited is willing to appoint Mr. R as additional director. They want to appoint Mr. R as the additional director of the company, and the articles of association of the company is silent about that. Is silent about having an additional director. Articles of association is not given the provision for appointment of it. Can you appoint an additional director if at all it is not authorized by your articles of association? Yes or no? The managing director of the company is of the view that the board does not have the power to appoint an additional director. Why? Because the articles of association is signed. You as a chartered accountant, you need to validate the situation in the lights of the provisions of the Companies Act 2013 and specify that this MNO Limited wants to appoint an additional director, Mr. R, but AO is silent. In that case, is it possible? Is it really possible to appoint Mr. R as the additional director? Think and answer. Your time starts now. Are we done? Yes. Are we done? Well, the answer is right in front of you. It is the provisions of the Articles of Association is needed, conferring the power to the Board of Directors. Unless and see, Board of Directors are not bigger than the Articles of Association. Articles are not bigger than the Memorandum of Association. Memorandum is not bigger than the law. So here, if the Board of Directors are appointing Mr. R as additional director, without the approval in the Articles of Association, without any kind of a power given in the Articles of Association, it will be considered as contravention of the law, right? It will be considered as an, what do you call that? Ultra Vires Act by the Board of Directors, and hence it should not be done. Am I clear? All right, let's go on to the next question. Mr. Z is proposed to be appointed as a director in a public company, RLP Limited. Mr. Z is already a director in one dormant company. Okay. In 2 Section 8 companies. Okay. In 8 public limited companies. So 1 plus 2, 3 plus 8, 11 and 9 private companies. That comes to 20. Total is 20. Yes or no? 1 plus 2, 3, 3 plus 8, 11, 11 plus 9, 20. 2 out of the 9 private companies are subsidiaries of public companies. What is that? This is something I can say. I am loving it. A CA final level question. Yes. Section 165, maximum number of directorship. A person can become a director in how many companies? And a note has been given, a proviso has been given over there for reckoning the number of public companies in which a person can be appointed as a director. The private companies which are a holding or subsidiary of public companies shall also be included in the count of public companies. This was the biggest hint I could have ever given. Well, your time starts now. Time is up, time is up, time is up. And your answer is no, Mr. T is already a director in 10 public companies. He wants to be a director in RLP Limited, but a person can become a director in how many companies? If you read section 165, it can be 20 companies in a combination of public and private, where public companies should be maximum 10. I will ignore the section 8 companies and dormant companies from the count of 20. All right. Here is a director in how many public companies? They said, sir, 8 public companies. 8. He wants to become an RLP, that is one more, that goes to 9. Well, 9 is less than 10. Then what is the problem? The problem is he is a director in 11 private companies, out of which 2 private companies, they said, are subsidiaries of a public company. If they are holding or subsidiary of a public company, then for the purpose of counting the limit as per 165, you should count them also as public companies. So 8 already, plus this 2 comes to 10. And now he wants to be appointed in RLP. That will be number 11. Well. We are sorry, Mr. Z. You cannot be appointed as per the provisions of section 165. Is that clear, Mr. Z? All right. Let's go on to the next one then on your screen right now. ABC Limited, who is a government company, has 14 directors. 14 directors are there. They are willing to appoint 2 more directors. All right, 2 more directors in the company to enable effective management of the company. How many? 2. Because they want effective management in the company. So 14 plus 2 goes to 16. All right. Mr. X, who is the managing director of the company, is of the view. What is his view? Appointment of 2 more directors is in violation to the provisions of company. Violation? Managing director, is it violation? Seriously? Yes. Or is there a provision in the company law to appoint more than 15 directors by passing some resolution? I don't want to say which resolution right now. Yes? Can you do that? Well, you have 4 choices. Answer is on your screen itself. Check it out. We will discuss it in 30 seconds. Time starts now. Time up. All right. 4 options are there. Let's focus on each and every option. Let's critically analyze. What is it? Critically analyze, scrutinize every option available. First one, appointment of more than 15 directors is in violation to the provisions of Companies Act. So 15 directors is the limit. You cannot appoint more than 15 directors. For all those of you who are watching this particular MCQ, this video, and have agreed that yes, this answer is correct, A is correct, I will tell you. Guys, get some general knowledge. Forget the law. Forget the provision of the law. Get some general knowledge. Go check it on the website. How many directors are there on the board of Reliance? Well, I don't need to tell you this answer is totally wrong. Next one. The appointment of more than 15 directors can be done by passing. Yes! For all those who got this answer, appointment up to 15 directors, no problem. More than 15 directors can be done by passing a special resolution. For all those of you who got this answer, your answer is absolutely wrong. Wrong. Sir, that is given in Companies Act. Yeah, really? What is given in Companies Act? Up to 15, you can appoint directors by passing ordinary resolution normally. And when it goes beyond 15, you should pass a special resolution that is given. Yes, sir, it is given. Yes. And when you read that provision, maximum number of directors in a public company, private company, OPC, whatever is there, can be 15. More than that, special resolution is required. After that, there is a proviso given over there. How did you miss that? Government companies have been exempted from the provisions of maximum number of directors being 15. Read the question very clearly what they have said. ABC Limited is a government company. One word, government company. You ignored the word, your attempt got skipped by 6 months if this was the 1 mark that you were looking for. Very important to understand the basics. That's what we focus in our class. That's what I have highlighted in our notes. Yes, go to option number D directly. That is, government companies are exempted from the provisions. Of maximum number of directors being needed. Yes, check the correct answer. The answer is, of course, D. All right. So that's the first top 10 MCQs that I have discussed with you. I hope you have understood them. I hope you have enjoyed them. I hope this idea of bringing an MCQ edition with you who wants to become a logician will help you to not only clear your concepts, because I am not only showing you the questions and answers, but I am also discussing the logic behind all of them. I hope this will be helpful to you. And if yes, well, don't forget to notify me about how helpful it is. Yes, it will only motivate me to do all the more MCQs for you, discuss all the more MCQs for you, and help you in whatever other way I can. All right. So, Harsh Kachalia signing off. Thank you very much, guys. All the very best for your exams, and I will see you around. Thank you very much.